done it, Archie. And I could watch it on the news. Long newsreel of Kamla Prasad Bisesa attacking the government, attacking me, and accusing the PNM of malicious, baseless prosecution of people. But I want to say one thing to you in the media. How come the PNM could have done that? All these people, especially local people, who are being said to have been prosecuted by the PNM through these charges, where would these charges have passed to get to the criminal court? Wouldn't it have had to go through the DPP office? So when you say the PNM has been prosecuting people who are before the court, aren't you automatically saying that the DPP's office, whoever is the DPP, all the staff in the DPP office was doing the PNM's bidding to bring charges against people where there was no evidence to charge them? Isn't that what you're saying? Because that is what self-appointed senior counsel, former Prime Minister, opposition leader Kamla Prasad Bisesa is telling the world. And I could tell you to the contrary, that nowhere in those proceedings about who should be charged, what they should be charged for.
No. Archie, while I'm going through this, because I'll be going through this for a little while, look and see in the previous clip, not that one, the one before, if you listened to it quietly in the back there, and hear if you heard this man change his tune on Nelson from being a Queen's Counsel and a great man to being something else. But I hold for you all, and this is just one element. This man tried to say that the PNM does not persecute, and Kamla lie. Kamla Prasad Bisesa is a liar. And then what you're talking about, the DPP? Yes, because the PNM has a history of trying to control the DPP. One could remember Geoffrey Henderson, the DPP, fighting against John Jeremy, the Attorney General of the PNM, and putting him in his place as they were trying to control. Furthermore, PNM Prime Ministers, including Manning, would veto and put who they wanted, just like Rowley would put who he wants in whatever office. Up to now, nobody thought you would put a recruit and a mini-me of Rowley as president, and we have it now. But Rowley is trying to pretend that the PNM never interferes with the DPP and other independent offices. Well, let me read for you for something from the Privy Council. And this is why we have to keep them old white man and white woman in robe out there, because them those suffer from PNM Balisay juice, and you could get a fair hearing and a real judgment from out there. Lord Hodge, Lord Sales, Lord Legat, Lord Burrows, and Lord Malcolm in an appeal, John Henry Smith, against versus the Attorney General of Trinidad and Tobago, and this had to deal with the matter involving Bastio Pandey, Sherman McNichols, Sat Sharma, and so on. Lord Malcolm said these appeals from two related decisions of the Court of Appeal in the Republic of Trinidad and Tobago concern an application for the recusal of a judge presiding over criminal proceedings on the ground of apparent bias. They arise in the context of a long-running and extraordinary set of circumstances. The test for such a recusal is whether a fair-minded and informed member of the public who consider the facts would conclude that these were real. Let me go forward. I had a lot to read for you from this, but let me not read all. Let me get to the crux of the matter for you all. Okay? Let's go to pages 23, 24, and 25. You all should get it and read it for yourself. Don't depend on an right judgment in John Henry Smith and another versus Attorney General of Trinidad and Tobago from the Privy Council. Right? And you could check it on Douglas Politics page, right? Archie says so. The board's views on the issues. Okay? No doubt there may be cases where circumstances peculiar to the particular country from which the case comes, perhaps local customs, attitudes, or conditions, are of direct significance and are matters which the local courts are better placed to assess than the board. However, no such factors are in play at the present case. Indeed, Council's submission on this matter never progressed beyond a high level of abstract generality. Right? To decide whether on these facts the observer would identify a real possibility that the judge was biased is not the exercise of our discretion, No doubt it involves evaluation and judgment, but the board is well placed to carry out the task, because they're trying to say that them out there wouldn't know. They don't want it to go out there because the PNM Balizé juice runs deep in our society. Given the lengthy recital of the background circumstances, it will be apparent by now that there were numerous potential causes for concern, concentrating for the moment on just one of them, namely the chief magistrate being beholden to the Attorney General, the PNM Attorney General, by January 2008, and in particular after the Mustill inquiry revelations, it was clear that no benign construction was available in respect of his receipt and banking of the $400,000, by then the full extent of his indebtedness to the Attorney General, indebted to the PNM Attorney General. This clown was in the government, and he comes out today to say there's no track record of PNM persecuting and getting involved in persecution of opposition members. That's what this fool came out Thursday to say. We read from the Law Lords. To the Attorney General, by then the full extent of his indebtedness to the Attorney General could be appreciated. It is not difficult to imagine his gratitude. He had the Attorney General to thank for resolving his serious financial problems and for shutting down an investigation into his reprehensible conduct. The reprehensible conduct is that of Chief Magistrate Sherman McNichols, who went to the then PNM Attorney General, asked for assistance. He was broke and he needed money, and the PNM Attorney General assisted him so much to ease his pain that the law lords say that he was hopelessly beholden. And this is where the conviction and all of this came through, and had to go quite Privy Council to get rid of Balizé juice. While the Pandey conviction was tainted by apparent bias arising from the desirability of the Chief Magistrate keeping the Attorney General on his side, it is noteworthy that it occurred on 24th April 2006. This land, the $400,000 to repurchase of his land, looked even worse for Chief Magistrate than it did in April 2007 when the Pandey conviction was quashed. At part 80 of the judgment, the Court of Appeal held, paragraph 101, that it cannot be assumed that the Chief Magistrate's decision in Piarco 1, Piarco, this big thing, section 34, all of that, this goes back before all of that, and the law lords are saying PNM political interference, PNM persecution, apparent bias, actual bias, malicious prosecution, right here. He ball Kamla lie. Kamla lie, you are the liar. The Piarco one were based on a desire to please the Attorney General. However, no such assumption is required for a case based on apparent bias. The board is satisfied, the Privy Council board is satisfied that even if focusing only on the Chief Magistrate's indebtedness to the Attorney General, the observer would conclude that the potential impact of this was not confined to the Pandey trial, but was also a source of real concern in respect of Piarco 1. And now you look past this, Piarco 1 get pelt out. If the Chief Magistrate might have had at least a subconscious desire to please the Attorney General and others by convicting Mr. Pandey, the same would apply, and perhaps more so at the decision time in respect of the Piarco 1 defendants. It is the beholdenness itself, not the precise circumstances in which it arose, plus the Attorney General's direct interest in Piarco 1. The PNM Attorney General's direct interest in Piarco 1. And on top of that, now in Miami, this man's Attorney General get pelt out a case after he was defending This defendant here, back in 2004 to 2007, then flipped the P&M now and going to attack his client with all the information that he had from discussions, and he lied on an affidavit to say he's just a note taker. Here, for all these reasons given on behalf of the appellants, the connection is plain and obvious. It follows that the board does not accept the Court of Appeal's view. So the Court of Appeal in Trinidad, P&M, let me tell you something, they so embarrassed themselves that the law lords are in shock that the Court of Appeal would have led to this judgment. They overturned, the board of the Privy Council overturned our Court of Appeal, that upheld this biased nonsense of the P&M. The appellant's case on apparent bias involves an extraordinary degree of speculation, says the Trinidad and Tobago judges. It is possible to offer an explanation as to how and why the Court of Appeal reached the wrong decision in each of the appeals. The court erred by rejecting the case of apparent bias on the basis that actual bias had not been established. Apparent bias and actual bias are two other different things. Similarly, in paragraph 104, it is suggested that the appellants failed to demonstrate that the observer would conclude that the chief magistrate was predisposed to determine the matters against the appellants or their co-accused. In recognition that actual bias is usually difficult to prove, no such demonstration is necessary, merely that there is the real possibility that the judge lacks impartiality. The above at 85. The above is sufficient for allowing both appeals. The constitutional claim succeeds because a tribunal which is seen to be impartial is part and parcel of both due process under Section 4 and a fair hearing in terms of Section 5. Now think about this while you're thinking about Kangaloo in President's House also, where y'all are saying now, oh no, she didn't go a P&M event, she is not, there's no actual bias. Even if all you see all the bias on the Senate and all they don't agree with it, apparent bias shows that there's a conflict of interest, and therefore someone who has and suffers from apparent bias cannot hold an independent office and hold and appoint independent officers, and then you feel that that would uphold the separation of powers. It does not work. It is wrong, and it is morally, ethically, and legally wrong. They continued. However, as will be apparent, if there were any doubt on the matter, the observer would have a number of other important issues to assess. They would include the absence of any reasoning for the chief magistrate's dismissal of the recusal application and the transparent attempt to avoid scrutiny by labeling it frivolous and vexatious. Because the defendant said, hey boss, you beholden to the Attorney General, the P&M with the 400,000, he help you out, think, come out of there, let somebody else sit down. The man say, oh, you're frivolous and vexatious. Who does talk like that? Not call me, but like P&M verbiage, right? And he refused to move. He refused to recuse because he had to sit there to carry out the instructions and the duty of this sick P&M. And he bawling people lie. This is a judgment from the Privy Council. When all the various sources of concern are considered, together with the observer, would be likely to agree with the appellant's submission that by January 2008, the chief magistrate was hopelessly compromised. Not a little bit of compromise. Not a little bit of balisé choose. Hopelessly compromised. For these reasons, the board allows both appeals and quashes the decisions of the Court of Appeal. In each case, it erred by failing to hold that the test for apparent bias was satisfied and that the recusal should have followed. Both the application for the judicial review and the claim for constitutional relief are granted, with the consequence that the Piarco 1 committal decision of 7 January 2008 falls to be quashed. Any other consequential matters are remitted to the High Court, and this man is still saying in 2013 his greatest moment was his email gate section 34 mass march with a set of labor leaders who would beholden to him, and everybody get fire. And he is talking about that as some feather in his cap, this dishonest, pathological liar. Section 34, to get off criminals. The law getting them off because of political persecution, bias, conflict, being compromised hopelessly by the PNM, punishing and oppressing political opponents. 18 years then after this, DPP say, hey, that case can't go nowhere. It never was going anywhere.